بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين على نبينا محمد وعلى آله وصحبه أجمعين. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another episode, appendix to our series on Islamic legal maxims, where we're looking at Islamic finance. And in our previous episode, we were discussing the types of sales, and that is the cornerstone of Islamic finance, the concept being that the bank is not simply a financial intermediary, but is engaged in bay', which Allah has permitted, as opposed to interest-based loans. And in our discussion, we discussed at length in the Qawaid Fiqhiyya regarding the permissibility of a markup on a delayed payment sale. And today we'll be looking at one type of the sales that we discussed in our last episode. And this particular form of sale was considered like the breakthrough contract in making Islamic finance commercially viable back in the 70s. Because as Islamic finance started out, people were groping. I mean, it was a time of intense experimentation. Nobody was sure that this project could be made viable. There were certain theories, and there was a ground reality, and how workable are these ideas in the circumstances in which these institutions found themselves having to operate. So how are they going to conduct their activities? One of the solutions was Murabahah lil-amir bishira. And so what that did was it took a classical fiqh contract, Murabahah, and tweaked it a little bit and came up with something that made it possible for an Islamic bank to conduct a sale with a markup, delayed payment, and it allowed them to operate within the same kind of context that banks operate. Now, we mentioned repeatedly that Murabahah is a trust-based contract, and the price consists of two elements. One is the cost to the seller, and the other is his profit. And it can be phrased as a certain amount, or it can be phrased as a percentage. So I was talking to an expert, the history of Islamic finance, and he's worked as an advisor with various firms, and is a graduate of Islamic University of Medina, and he has a law degree from the U.S., a very learned man. And so I said, why is it necessary to call this kind of a sale Murabahah? Couldn't you just as well, from the bank's point of view, if you're charging, it costs you 100 and you want 20% or 10% profit, and you figure it all out, you come up with a price, why can't you just call that price that you've arrived at by whatever means, why don't you just call it musawama? You just give the customer a fixed price. And he said the reason that they chose this format is because if you're running a bank, you have to fit into the regulatory structure of the banking system. Every country has rules by which banks operate. And so they look at principal and interest. And so for the Islamic bank, for them to be able to divide their transaction into a cost plus a profit meant that their accounting could be done in terms that were understandable to the regulators and would still be Sharia compliant. So, I mean, the critics say, well, it looks like a duck and it quacks like a duck and it walks like a duck, so it's a duck. But the response to that is, I heard this from Sheikh Taqi Uthmani. He said, a man has intercourse with a woman, and he has gone through a certain procedure where he approached her father and asked for permission to marry her. The father agreed. The woman also agreed, and he gave her a gift upon marriage. So, according to the Sharia, the relations between that man and that woman are recognized and lawful. Another man doesn't go to the woman's father. This woman is a prostitute. And he goes and he pays her some money and she agrees. And they have sexual relations. The act is the same here and there, but it's framed in a different context. One context makes it legal and the other makes it illegal. So the sale with a markup is recognized by the Sharia as lawful. Now, if someone were to say, well, what is the Sharia evidence for this kind of sale being lawful? The question then would be asked of that person, upon whom is the burden of proof here? The one who says it's lawful or the one who says it's unlawful? Ahallallahu al-bay' is a comprehensive statement. This is a form of sale. Allah has made sales lawful. Murabahah is a sale, therefore it is lawful until proven otherwise. And the Prophet ﷺ, when he was laying down, outlining the prohibitions related to riba sales, he talked about certain categories that you can't exchange them except like for like and spot transaction. And then there's certain other categories if the transaction is cross-category. Then he said you can sell as you want as long as it's a spot transaction. And then when you get outside of those, then a delayed payment is lawful and the amounts that are exchanged do not have to be the same. So he said when the categories differ, then sell as you wish. So here, one of the subject matters that's not allowed for murabahah is gold and silver, or currency, because those are governed by the rules of sarf, currency exchange. And one of the rules for that is that the transaction must be concluded on the spot. So the way that murabahah is structured is that it's a delayed payment sale. So anything other than sarf can be subject for. Anything other than exchanges of money can be structured as murabahah. And it's also mentioned that there's specific instances of some of the Sahaba, they mention Uthman radiallahu anh, engaging in a sale of this type, and it was a matter of consensus down through the ages among jurists that murabahah is lawful. And murabahah can be conducted between individuals, or it can be conducted between corporations. It can involve governments. It can involve governmental institutions. So the areas of its application are wide. Now, we were saying earlier that there was a traditional classical fiqhi form of murabahah that got tweaked when it was applied in Islamic finance. So what is the difference between that classical form and the current form? The classical form involved only two buyers, and it could be a spot transaction or it could be delayed. And normally what would happen is that the buyer walks into the store and he wants to purchase an item, and the man says, well, I paid 100 for it, I'll take 20 as a profit, give me 120. And if the buyer agrees, then they can conclude the sale. Or the seller could say, it cost me 100, I'll give it to you, pay me 150 after 1 year. And so both of those are okay. Now, the current form of murabahah is called Murabahah lil-amir bishira, Murabahah for a purchase orderer. And so what that means is that a customer comes into the bank and he says, I want to buy this thing, I don't have enough money, I want you to buy it and then sell it to me. And so what that means right away is that there's going to be three parties involved in this overall transaction or arrangement, let's say, because it's an arrangement that consists of more than one transaction. Based upon the negotiations with the customer, which involve specifications of what exactly it is that the customer wants, and the price plus the markup, the cost of the item, plus the markup that the bank will charge, and the payment period, all of those things are discussed up front. And all of that discussion ends with the purchase orderer signing a contract by which he agrees that if and when the bank buys the item that matches his needs, what has been specified in the arrangement, that he promises to buy it from the bank. Okay, it's time for a break.
Say indeed, my prayers, my sacrifice, my life and my death are all for Allah, sustainer of the world.
A dynamic.
I challenge any human being to point out a single fundamental of Islam
In youthful quest.
Which is against humanity as a whole.
Iconic, inspiring, encouraging.
Don't judge Islam based on the following.
Farik Naik.
Judge Islam based on the authentic sources, that is the glorious Quran and the authentic Hadith.
Son of the world-famous orator on Islam and comparative religion, Dr. Zakir Naik.
Allah subhanahu wa ta'ala is giving us an opportunity to do a prophet job and to earn a prophet's reward.
A star above par in Teens Star. Next on Peace TV.
Assalamu alaikum wa rahmatullah, welcome back. So we're talking about the difference between classical murabaha and the contemporary murabaha lil-amr bil-shira that's become a feature of Islamic banking. The customer comes in and explains what he wants, the bank negotiates, they check out the customer, they check out the goods, they check out the customer's ability to pay, and so they reach an agreement in which the purchase order promises to buy the good when the bank purchases it. And so right now this is not a contract because the bank hasn't sold anything to the customer yet. And it's not allowed to sell that good to the customer because the Prophet ﷺ said, "La tabi' ma laysa 'indak." The bank doesn't own this good, so it's not allowed to sell it. So what is signed by the customer is not a contract. It's a promise that outlines certain issues which will have contractual weight if the bank does end up selling that good to that customer. So that's a preliminary agreement, which is not a contract. Now, the bank would turn around and find a seller that will sell that good. I mean, this has already been kind of worked out in the initial investigation, so the price is already known to the purchase orderer. So this preliminary investigation and negotiation gives the purchase orderer a pretty firm knowledge of what it is that he will be getting and what his obligations will be. Now the bank turns around and they make the purchase from the seller. So here you now have an arrangement where there are three parties. You have the bank, you have the purchase orderer, and you have the original seller. Once the bank takes possession of the good, then the bank becomes a seller, and it sells the good to the customer. And this modern form of Murabahah is a three-way contract. Now, in an ordinary classical Murabahah, the seller faced the normal kind of market risk that any merchant faces. He bought the good not knowing if there would be a buyer. And so all of those risks of not being able to sell what the retail has purchased, and then the cost of storage and all of those things, those were the normal kind of risks and costs associated with classical Murabahah. The bank in a contemporary Murabahah doesn't face that market risk at all. And according to the ruling of the Islamic Fiqh Academy, it's perfectly okay that they don't. The customer comes to it with his proposal, and the ruling of the Islamic Fiqh Academy is that when the customer signs that agreement, then he is bound by it. The bank at this point is not obliged to go ahead and purchase that item, but the buyer is obliged to purchase it from the bank if the bank does go ahead and buy it and then offer it to him. So it's a one-sided promise. Now, why can't the bank also sign that initial agreement? Because if both sides make bilateral promise, then according to all scholars, I'm not aware of any difference of opinion on this, a bilateral binding promise on both parties, there's no difference between that and a contract. And therefore, you get into that prohibition that the bank is selling what it doesn't own. So that initial agreement is one-sided promise. Then when the bank takes possession, it offers the good to the customer, and the customer buys it. Now, because the bank already has a customer lined up, it's not facing market risk. It neither buys nor takes possession until it has a buyer. In traditional fiqh, the classic Murabahah, there was no need for a promise. The customer walked into the shop, he saw what he wanted, and he was informed of the price plus the markup, and he paid it and walked out with it. In the classical Murabahah, there were only two parties. In the contemporary Murabahah, there are three parties. And of course, that classical Murabahah is an old contract that if somebody were to do it today, those classical scholars, if they saw that transaction, they would know what it is right away. That kind of Murabahah that is now being used in the Islamic financial system is not exactly that contract. It's been tweaked in order to make it serve the needs of the contemporary situation. Now, the stages of this Murabahah contract, there are four. The first stage is the promise. The second stage is the bank taking possession of the good from the primary seller. And then there's the sale and the execution or delivery to the end customer. Now, if a customer comes in and he's already negotiated with the seller who is actually making this good, then that raises certain issues. The customer is not supposed to enter into an agreement with that primary producer. And if he has some kind of agreement with the primary producer, that agreement has to be canceled, because the bank has to actually buy from the primary producer and then, in a separate contract, sell to the customer. But the customer can come to the bank and say, you know, I've been doing research on the issue. This is what I want, and I would like it from that producer. And the bank can agree to that or say, well, you know, What we agree to is to provide you with a good meeting these specifications, and the bank can refuse to deal with that particular seller that the customer was initially contacted. Also, the issue arises of agency in a Murabahah contract. Scholars have ruled that it is lawful for the bank to make the customer its agent. So after the bank has entered into a contract of sale with the producer and payment has been made, the customer can go to the producer and take delivery on behalf of the bank. And then the bank turns around and sells the good, which happens to already be in the hand of its agent. No longer is that customer acting as the bank's agent, but there's a new contract in which the bank is the seller and the customer is acting on his own behalf, now takes possession from the bank, and physically nothing has happened. I mean, the good was in his hand, but he's no longer acting as the agent of the bank, he's acting on his own behalf. Now, this particular issue could have serious ramifications about whether the contract becomes just a cover for something else. And there was a major kind of case that came up in Islamic finance where an arrangement like this had been worked out, where there was somebody who was buying jewels by Murabahah, and the bank had assigned the customer to be the agent. And in fact, the bank was totally unaware of what was going on, and the agent ended up not being able to pay, and it all ended up in a court. And what kind of a court? A British court. And when they looked at the thing, they said, you know, this is just a financing agreement that looks like a sale. So it was an embarrassment to the Islamic finance industry because of this looking at form and ignoring substance. We've come to the end of our time. Assalamu alaikum wa rahmatullahi wa barakatuh. Allahu a'lam.